Good afternoon and welcome to this extended interview with one of the pivotal players in what is sure to be one of the most talked about stories in British legal history. Following ITV's recent dramatisation, Mr Bates versus the Post Office has become a case everyone in the country is talking about, and I'm delighted to be joined by one man who knows a lot more about it than most. James Hartley is partner and national head of the dispute resolution team at law firm Freeths, and it was his team who finally managed to bring about justice for hundreds of sub-postmasters in the most widespread miscarriage of justice this country has ever seen. James has been involved with this case for nearly a decade, giving him and his expert colleagues an unparalleled perspective into how a complex group action case like this is won and what lessons could and should be learned by the rest of the corporate world. James, thank you so much for allowing me to chat to you today in what must be a very busy and surreal period for you.
Absolutely, very busy, very surreal. And absolutely wonderful, though, to see the profile of this for the postmasters, because that recognition publicly as to what went wrong and they did nothing wrong is all part of the process for them of closure.
Now, I'm going to assume that most of our audience that are joining us today know quite a bit about this story already, and obviously the wronged sub-postmasters. But I'd like to start by asking really how and why you first became involved in the case. Yeah,
and in actual fact, it is depicted really well in the ITV drama. So back in 2015, on the way to work, hearing James Arbuthnot on BBC Radio 4 talking about the campaigning that Alan had been doing. And that struck a few chords. And then that led me to contact Alan Bates, and we then opened the discussions and off we went.
Tell me about that. What did you make of Alan when you first met him?
We met in a hotel in Chester over a coffee. And Alan was, again, Toby Jones captures it perfectly. Alan, very reserved, wasn't giving too much away at the time. Little bit sceptical as to whether or not another lawyer or another law firm could actually crack this, because obviously Alan had been working on it since 2008, 2009. So the discussion went slowly, to put it that way.
And what do you think he took away from that meeting with you? What did you hope that he thought of you after you'd had that first meeting? Because this was a case, you must hear of many, many cases, but this one had really struck a chord with you. So what were you hoping for?
Well, what I was hoping for was that Alan would believe in us. And when I say us, at that stage, it was myself and then the team around me at the time, so Imogen Randall, Chloe Oram, and we were very early on quite deeply invested in the case once we started hearing the postmaster story. So we wanted Alan to believe that we believed in it, put it that way, rather than Alan just thinking, right, well, these guys could probably do it, they're litigators. We could tell that he needed to trust us and trust that we would follow it through.
So that was the very personal human connection that was required at the start. But also, what made you think that Freeths could do this when other law firms had tried and failed? It must have been a very daunting prospect with the knowledge of the human costs that there'd already been in this case as well.
Yeah, it was a significant challenge because we could see that a couple of firms had looked at the case before. We could see that there were dozens of postmasters who had pleaded guilty, in actual fact, to false accounting, which was a challenge in the case. We could see we were beyond the 6-year limitation period. We could see that Post Office had in its possession a lot of the evidence, the data, the documents. And also we could see that Post Office were going to fight this. They had a track record of doing that. They had fought Lee Castleton in the High Court. With significant consequences. So we knew they'd fight it.
That was an extraordinary case in a sense, and a real indicator of what the battle was ahead, wasn't it? Because they pursued him at a cost of hundreds of thousands of pounds in legal costs for what was a £20,000 loss.
Exactly, and that was it was a striking case to us because we could see the lengths that they would go to, and that they, in that case, would show no mercy, to put it bluntly. So we were very conscious that in addition to the sort of legal evidential challenges, it was going to be a long battle. We needed to prepare for that, and that's what we were saying to Alan, that we have to get ready for a very significant, lengthy battle through the courts.
So the odds were really stacked against you, and on top of all of that, you had to persuade your senior colleagues in the firm that this was a good idea as well.
Yeah, I mean, because it was going to be such a major case, we'd assembled our team. We knew there was several years of work to do. We knew it would take us about a year to build the case, so we were working without payment actually for about a year, as was the barrister team once we got them on board. So Patrick Green, KC, and his team at Henderson Chambers, again, working for free for about a year. This was all a building process. And absolutely, I was saying to my firm, Freeths, this looks like a good case, despite the fact that we're going to be litigating against a government-owned entity that's a trusted brand with significant amounts of money. There are all sorts of reasons why we shouldn't do it.
And there was a real passion lit in your team about this as well, wasn't there? There had to be.
There really was, and that came principally from meeting a number of the postmasters on a one-to-one basis, which tended to happen at the group meetings that we had. And hearing the stories, myself and the team hearing the stories of the postmasters, one after the other, the harrowing stories, meant that we were steadily building a determination to really build the case and see it through. And that's what was needed across the whole team. Alan's had it all the way through. The postmasters have had that determination all the way through, but we needed to have it to actually get through it turned out to be about 4 years of pretty brutal litigation. So that belief in the cause was enormously important in the end.
Now, you needed that belief, but then you needed to persuade hundreds of sub-postmasters that they should have that faith in you and your team as well. That was quite something that needed to be done, and it required your whole team effort from, a marketing team reaching out to those people to start with and literally stuffing envelopes full of packs to send out to sub-postmasters. There were key parts of the business that are customer facing in that way for Freeth that needed to reach out to those people. It wasn't just the legal experts you required at that point, was it?
That's right. It was a sort of broad project in building the group. Once we'd agreed with Alan that we needed to build it beyond the initial 80 or 100, and then building the group involved building trust, getting their confidence, getting the postmasters' confidence, and reassuring them that there was safety in numbers, which again comes out from the ITV drama. It's absolutely the case that there was palpable fear on the part of many of the postmasters we used to talk to and the team used to talk to about joining the group. We quite often get the answer of, well, yeah, but surely you can't beat Post Office, or what will Post Office do to me? I'm still a postmaster, or so there was absolute fear. But as the group became larger, the confidence grew. They got to know each other, and the collective trust in themselves and in the legal team built. You
talked there about the safety and numbers aspect, and there were some extraordinary things that happened even when you were carrying out those group meetings, where the Post Office did show that they were going to continue to fight this case. You had Post Office moles, if you like, coming and trying to get access to those meetings and that information. Yeah, we could see each step of the way what we were dealing with in the former Post Office. Things began to look a little sinister when numerous of the postmasters were telling us that they were the only one. I mean, that started early on. I'd already met Richard Roll very early in our investigation process, and he told me about remote access and things like that. But yeah, other things happened. So in one of the group meetings where we would invite a lot of postmasters along to tell them about the case and give them a confidential pack of documents so they could understand what the case was going to be about and how the funding would work, turned out that an individual at the back of the room had got hold of one of the packs,
and when challenged, said, "Oh, sorry, I must have come into the wrong conference." Clearly, he hadn't. Now, we don't know whether Post Office knew that person was there. He clearly had decided to go in there to obtain some information. It was that kind of tactic that told us we need to be really, really careful as well in terms of what information got out to Post Office as the case progressed.
So you needed to have a very tight-knit team that information didn't get to anybody you didn't want it to get to, and that required Alan, I guess, being a bit of a figurehead for that group of people as well. 550 people is a lot of people for you to deal with each of those individually. There became a sort of steering group, if you like. For the
Absolutely,
group.
And it's common in group actions for there to be an appointed steering committee, which there was in this case, and Alan was chair of that committee. And we'd agreed with the postmasters at the outset that they would appoint contractually the steering committee to make decisions on their behalf, because it'd be impossible to go out to 555 people individually on every decision. So that decision making was given by the postmasters to the steering committee, which lasted all the way through the case.
Now, the reason it was crucial for you to find all these sub-postmasters was obviously safety in numbers, as you've described it, but also the crucial funding. And that's something that a lot of people have obviously shown a lot of interest in. Why was litigation funding necessary? How was it brought about? And was it a fair deal for the postmasters? Talk me through what the process was to be able to even get this case to court in the first place.
So it was essential from day one. And that was a conversation with Alan when we said, and he said, well, the postmasters don't have any money to spend on litigation. We knew it would cost millions to run the case, to instruct the barrister teams, technical experts. So we knew we would need funding. Fortunately, we had good links with litigation funders in London. So we said to the postmaster group, the only way this case can ever get off the ground is with litigation funding. But the price that one has to pay for litigation funding is that the funder is risking their capital, in this case north of £10 million. And if we don't win the case, they lose their capital. Therefore, the commercial return for the funder, which is standard in the industry, tends to be a multiple of 2 or 3 times their capital. So they put the capital in and they get a return. So the postmasters agreed, quite rightly, that yes, it's the only way we can go.
And actually, it turned out that it wasn't very easy to get that funding anyway. There were several firms that wouldn't do it at all. So it was a very difficult, complex case for any of those funders to even touch.
Funders will only invest in cases once they know the merits are strong and that the economics of the case work. And to convince funders to invest, in this case, involved getting the counsel team on board for them to advise as well that the case was strong. And we brought in Patrick Green, KC, and the team, and they invested the time. So we needed to get the counsel team to give positive advice on the case along with us. And we needed to do an awful lot of work to demonstrate to the funders that we could win the case. And Ethereum, thankfully, was the funder that agreed to invest. And I think that part of the reason they did that was not just because they thought it was a good case in the end, once we'd gone through it with them, but also they could see that this was a way that they could help give access to justice. That did matter to Ethereum. And I think the other funders that decided not to fund the case, for whatever their reasons were, I think they did miss out on an opportunity to actually fund a very significant case. And
Freeth's expertise comes in there because you were very good at mapping out the exact kind of outcomes and what you would need to be able to fight this battle, however large the opposition was.
Correct. And that again meant that we needed to not only convince ourselves, but convince the funders that we had pulled together quite a sophisticated team. Not the largest of teams, because we tend to find strategically that it's not just about the size of the team. We'd pulled together a very efficient team that worked seamlessly really across solicitors firm, i.e. Freeds, and the barrister team as well, and also the expert, and then combining that expertise with the use of technology was all part of the process to convince the funders that actually not only have we got a good case, not only is this a good cause to give access to justice, but the team that they are investing in is up to the job.
And the fact remains that the Post Office chose to fight this to the lengths they did. And we were looking at sums now that are eye-watering that have gone into this case. It's not just the costs to defend it or for the sub-postmasters, but now the compensation payments and the legal costs of the Post Office, we're running into sort of billions here. We are.
I mean, estimates vary, but and the cost goes up all the time. But an estimate of 1.5 billion was the last that I heard for both compensation and costs. And we may talk a little bit more about the fact that that could have been avoided had Post Office done things differently from the outset.
And at the end of the day, the postmasters did know that this was the deal. Do you believe they got a fair deal?
They absolutely did get a fair deal, in the sense that had it not been for the project with the funding, unfortunately, I don't think it would ever have got off the ground. And Alan Bates had an article in the Financial Times a couple of days ago when he was making exactly the same point, i.e. that without the funding, there was no way it could have got off the ground. So I think that also everybody involved, including Freeds and the barrister team, did all that we could to make the deal as good as possible when we ultimately resolved the case through mediation. So we Freeds decided we didn't take any success fee, we just got paid for the work we did. Same with the barrister team. The funder didn't take the contractual sums they could have taken. So in the end, it was the best possible deal we could get in the circumstances, and it was all part of what we'd hoped was a bigger game plan.
Well, this is what I was going to ask you next, because you're still involved. It didn't stop on that day that you won the cases, did it? You're still very much involved with the compensation scheme now.
Yeah, we absolutely are. And the two High Court judgments that we obtained from Mr. Justice Fraser, the Common Issues judgment and the Horizon judgment, absolutely provided the foundation for what's followed, including the setting aside of the unsafe convictions, ongoing public inquiry, three compensation schemes, one of which, as you say, we're still involved in now, acting for 400 of the original 555, and we're pushing that forward as quickly as we possibly can to obtain compensation. So we want to finish off the project that we started, and as I say, when we'd got the High Court judgments and then the case settled shortly after that, there was a lot of campaigning that was then happening, including from us and our MPs, which thankfully have led to where we are now.
So just going back slightly now, so that was a year of hard work to get to the point where you could bring this to the court at all. The trial dates were set, and then there were two trials.
That's right. There were two significant trials in London. The first, the Common Issues trial, which was for the court to determine the nature of the contractual rights and obligations between the parties, which was far from straightforward. And going back to when we were first trying to build the case, it was clear to us that it was a very, very one-sided contract between Post Office and the postmasters. And we found that we had to be quite creative in the contractual arguments we were running. And the Henderson Chambers team were incredible in the way that they were able to formulate arguments based on implied terms, which it's never attractive for us to have to pursue a claim based on 12 implied terms. But we did it, and thankfully that worked, and we won the first trial, the Common Issues trial, and the court found that amongst a whole raft of findings in a very, very long and detailed judgment, that Post Office had a contractual duty to act in good faith, amongst other things. Then the second trial, the Horizon trial, again a very significant trial. That one was all to do with the Horizon system and whether it was robust or not, and whether it had defects.
And this second trial was the one that you knew you had to win even more for the postmasters themselves, really?
Yeah, the first trial was just the beginning. Second trial, yes, we absolutely had to win it to establish there were problems with the Horizon system. There was then going to be another 2 full trials, at least 2 full trials. Again, which would have cost millions, tens of millions of pounds to pursue it all the way. So there was still a long way to go.
And there was an extraordinary event where the Post Office tried to have the judge removed as well.
Yeah, that was their recusal application, which was halfway through the second trial, halfway through the Horizon trial, which was an extraordinary move, unusual move, and one which will come under scrutiny and is coming under scrutiny as part of the public inquiry. But yeah, that was extraordinary because the judge had found against them in the first trial, and they had appealed large parts of that first judgment, and then they launched the recusal application to remove the judge from the case, which of course did not succeed, and went to the Court of Appeal. The Court of Appeal were scathing, actually, as to the basis for that application, and they kicked that out as well.
And a cynic might say that all the time this was happening, that it was chipping away at your funds as well, and money was running out.
That's absolutely right, and the more that the money was running out, then clearly the more pressure we were under and the postmasters were under, because it couldn't go on forever. And the economics of the case were under pressure as far as the funders were concerned. And the more funding, had there been more funding available to carry on, which there wasn't, even then, there would have been diminishing returns, because for every £1 million of funding, one obtains, that costs a lot of money, which unfortunately under UK legal rules, it is not clear that those funding costs can be recovered from the opponent. So the returns to the postmasters were diminishing all the time.
So with all of that in mind, how did it feel when you walked out of that court and you knew you'd won for them? Even knowing in the back of your mind, this has cost so much, both financially and emotionally. How did it feel when... It was a bittersweet, to say the least, because on the one hand, we had achieved very significant success in both of the trials, and they were significant. Those judgments have proved to be the foundation for everything that's happened since. And we knew at the time that those judgments were significant. And we were hopeful that they would lead on to most of the things that have happened now, but we couldn't be sure. So on the one hand, it was incredible, and we felt that we succeeded. But again, as per the ITV drama, understandably, a lot of the postmasters felt that, well, we're winning. Why settle now? So that was really, really hard to reconcile. On the one hand, the harsh realities of litigation and a very complex financial project, which is what it was, and on the other hand, the very understandable emotional drive that the postmasters had to see this through and see it through all the way. So they were incredibly difficult things to reconcile. Yeah. But perhaps fortunate you had the pragmatist of Alan Bates at the head of it all.
Very true. And Alan and Kayleigh Nell, throughout the whole thing, did an absolutely incredible job of keeping everything on an even keel and explaining to the postmasters what was happening and why it was happening, and that was absolutely essential. But I mean, even on things such as when we finalised the settlement, £58 million with Post Office, and a lot of the money went in funding for all the reasons I've mentioned, and that's through no fault of the funders. That is just the way it works in these commercial deals. Alan was explaining that to the postmasters and reminding them that right at the beginning, it was made clear that the funding would be very expensive. So that was enormous. So it was, as I say, great to feel the success of for the postmasters of those judgments, but equally really, really hard to settle a case.
You knew there was still a bit of a journey ahead as well. So with all of that in mind and that sort of wealth of experience that your team and yourself have gained from this now famous case, I guess it's a career-defining case for you now, James, personally as well. What lessons do you think need to be learnt, should be learnt, could be learnt from both a corporate point of view, but a legal one as well? Perhaps if we start with that corporate sort of outlook, other companies now must be looking at this and saying, where did they go wrong? What can we do to mitigate against these risks? What do Freeths do in terms of that to actually get ahead of some of this now? And how do you use that wealth of experience that you've gained from cases as high profile as this one to help clients going forward?
Well, I think the first thing I'd say is on the lessons learned side of things, we'll see what the inquiry concludes, and the 218 questions and issues that the inquiry is looking at, all highly relevant to get to the bottom of what went wrong, why it went wrong, who's accountable, and the inquiry is looking at all of the right questions involving all of the right parties. So let's see what comes out of that. From Freeth's perspective, and from the experience of the case itself, but also advising corporates on how to avoid very significant litigation or regulatory risks escalating. Common themes that come out to us and that we talk to with our clients can indeed be seen in the Post Office case, which are several in number, but they include dealing with embryonic issues as and when they emerge and confronting them and managing them, which includes as well bringing in the right people. So internally, bringing in the in-house lawyers, bringing in the subject matter experts, bringing in external lawyers where necessary, but bringing the right people very early on, not to over-engineer situations, but just to start steering them in the right direction. But also importantly, to look at the outcome scenario planning side of things, which includes building in risk management techniques as well. And we see that with our corporate clients, the ones that do that forward planning and outcome scenario planning are the ones that do indeed find that they can achieve the better outcomes. And we Freeths do help with that. So we use our systems. We've got an ARC system that we apply when we're talking to corporates about how to manage that sort of risk. So the forward planning aspect is important, but also fundamentally is having, and again this comes from the experience of the corporates we work with, having a principled context in which to make strategic decisions. So one way we talk to clients about it is having a sort of tripartite bottom line focused on people, planet, profit, so that the business is looking within itself at whether things are happening or decisions are being made which are or could have a significant impact on people, whether that's within the business or externally, or whether things could have a significant impact on the environment, and obviously looking at profit and the bottom line as well, but not solely at profit. So that foundational approach to corporate social responsibility provides a context for decision making, as does culture within the business.
This is what, because culture and the transparency in a culture that people can come forward with concerns, it's so crucial, isn't it, to be able to listen to whoever it is from whatever team it might be, because the general public might access a company via their social media account or their press office or their marketing department. It won't be coming straight into an in-house lawyer. All those departments have to be absolutely on the front foot with any issue that might arise. That you can't ignore. You've got to nip these things in the bud.
Yeah, it's essential, but because the board of a business can't know everything about every aspect of the business. So, as you say, the more there is that culture of openness, transparency, then the more that relevant information can be fed up through the business and within the business as well. So that applying that to the post office case, potentially with the benefit of hindsight, but that kind of culture and approach within the post office business back in the early 2000s may, for example, have resulted in the board being made aware of concerns about how robust the information was upon which prosecutions were being pursued, and other issues such as the extent to which there was proper disclosure of documents and information. So that kind of dialogue would have been much more likely to have happened and found its way up to the board.
The more open a company is, the less likely those things are to happen in the first place. And I guess these companies, there is a pressure to be financially viable all the time, and you know that's where the profit bit is becoming before the people and planet, as you described it.
Yeah, and this is where businesses say to us that the more sophisticated they are in how to create value within their business by doing the right thing, by operating within the rules, as it were, the more they do that, the more they are making their businesses resilient, and the more they are adding value within the business, which in turn also makes them more competitive. So these are issues which are very much on the agenda of the sophisticated corporates, and as I say, those are the ones that are really getting ahead of the game.
And what about the repercussions for the legal profession? Because obviously there's been a lot of outrage really at how complicit were lawyers in all of this mess with the post office. And should the Solicitors Regulation Authority be involved? I think they've said they will start looking into things once the public inquiry is over. But what lessons have to be learned by lawyers in all of this?
Well, we will see what the inquiry concludes on that, and then in turn we will see what, if anything, the SRA and the Bar Standards Board do. So we shall see. What, though, that the post office case is, it is a really important reminder to us all in the legal profession as to a number of things that are well established in principle, but in practice they can become quite blurred. The lines can become quite blurred. So, as lawyers, whether it's in-house lawyers and external lawyers, we all know that we are officers of the court. We are supposed to operate with independence, and we have to assist the court in achieving just outcomes. But we have to balance that with also acting in the best interests of the client. Again, using the post office case as an example, without attributing blame to any particular people at all, if lawyers are instructed to take a very aggressive approach in litigation by, for example, applying to recuse the judge or applying to strike out large rafts of our evidence before the common issues trial, and that kind of thing, is that something that the lawyers are instructed to do and simply should do on instructions? And if so, is that permissible? In actual fact, as lawyers, we have to remember that we have to take quite a lot of ownership for the strategy of cases, particularly in court when counsel are acting as advocates. We're not permitted simply to say, well, we are instructed to do this, so we're doing it. And I think within the business for lawyers, we have to find ways of not only operating within the rules, because that ultimately is in the client's best interests, but fighting hard within the rules. But we have to find a way of doing that whilst at the same time talking to our clients about why that is actually in their best interests. And
at the same time, you're obviously maintaining your important relationship with your client. In this case, the sub-postmasters. And I know we talked earlier about when you were gathering together, you had the steering committee because you needed to have a little a little group who knew the case inside out, who you dealt with, who you could make agreements with, for example, agreeing the settlement in terms of when the outcome of the trial was happening. You needed to make sure those communications were there and building that relationship with your client whilst you're carrying out an incredibly complex legal case. There's a lot of different aspects to how a lawyer must act.
And that can be quite challenging in a group action. Where we owe individual duties of care to the clients, but from a strategic point of view, as you say, in group actions we need a steering committee. The individual clients give authority to the steering committee, and so that can present additional challenges when decisions are taken in the interest of the group as a whole, while certain sections of that group may not entirely be happy with certain directions of travel in the case. So that can add even more complexity to the duties on lawyers.
We did mention there that the public inquiry is ongoing and they're expected to be obviously a huge report and findings will come out of that. But what would you see would be valuable to come out of that? Would you like to see accountability? For example, have Fujitsu really been held accountable for their involvement? Because we talk about the post office a lot, but it was Fujitsu's Horizon system. So, what would you like to see come out of that public inquiry?
I think first and foremost, and there was a piece on the Today programme on Radio 4 this morning about this very subject as to what does justice look like for the postmasters or people who've been through other situations such as the Hillsborough disaster or other similar scenarios. What does justice look like? And I think it's pretty well established now that has to include those affected people seeing individuals held to account one way or another. So rightly or wrongly, that needs to be seen. So I think that will hopefully be one of the main benefits that comes out of the inquiry. That it will help the postmasters as part of their healing process and closure process. But also equally important, of course, is shining a light on what could have been done differently within Post Office and potentially Fujitsu as well. And also from the lawyer's perspective, again, a reminder as to where those lines are that I was talking about a few minutes ago. So quite what will be done in terms of action taken against companies or individuals. No point in us speculating on that at the moment, but I would be very surprised if there wasn't some kind of action taken against more than one.
And there are police inquiries that are continuing as well in terms of both perjury and fraud. And now we're seeing, just last week, we're hearing that the Post Office may now be being looked at by the Inland Revenue because they may have actually mispaid tax with 100 million in compensation not being potentially put into their bottom line. So there's a lot of complexities going forward with, the Post Office are going to be scrutinised now. And
I absolutely. And I think this is, again, brings us back to reputational damage that comes from these situations. So Post Office's reputation, I think there is quite an unusual tension. On the one hand, the British public feels very strongly now about Post Office Limited as a corporate, very strongly. Whilst on the other hand, they have fond thoughts towards the postmaster or mistress in the local post office. So there's an odd tension there. But I think that the only reason Post Office as an entity still exists is because it's publicly owned. Otherwise, I think any other corporate in this situation would have been not viable a long time ago, both financially and reputationally. So that is, whilst this case is very extreme and very high profile, that is absolutely not to say that these sorts of things cannot happen to other organisations, because they have and they can and they will.
Now, it's obviously more than 4 years since that case, and people thought that was a great conclusion to police involvement potentially, but definitely not. I mean, you've been involved ever since, and you're very involved now going forward with the compensation schemes, and that seems to be evolving, by the hour at the moment as well. Last week in Parliament, we saw new compensation schemes being offered. And what's your view on all of that? And what is the satisfactory outcome? And what does Alan Bates and his cohort feel is a satisfactory outcome? They can never really get so much back that they've lost, but what does the financial outcome look like?
Well, the financial outcome will result in each of the affected postmasters receiving fair compensation for the damage and the loss they have suffered. We're not in a US type system whereby punitive damages are awarded regularly. We see massive awards which are meted out to punish wrongdoers. We very occasionally have it, but even in this case, we don't have punitive damages. So the postmasters will put in evidence and are putting in evidence, which is what we're doing for 400 of the original 555 in the compensation scheme, and the same is happening in the two other schemes at the moment. So the postmasters will receive compensation. It's a slow process, and part of the reason it's slow is because it's government taxpayers' money we're dealing with here, so it takes government quite a long time, or has done up to now, to actually get these schemes set up. The government moved very, very quickly last week for obvious reasons, because the spotlight was on everybody. But the compensation will flow, and the really comforting thing for the postmasters is that government is not going to turn the tap off on the money for this now, which at one point was a concern that we had. But this has moved well beyond that. This is not a question of, well, how much will it cost? This is a question of, right, how quickly can we get this done? So for us, the main focus is pushing forward the compensation scheme that we're acting for the postmasters in. We've got over 20 lawyers working on it as we speak. And there are various other law firms working on it. So that's the absolute focus now, to get that money paid out as quickly as we can. Absolutely,
because these people are only getting older, and indeed people have died waiting for this compensation. It's crucial that it speeds up.
Yeah, and I think that some of the claims are relatively straightforward. So those postmasters who haven't had their lives ruined, they haven't lost everything, are going to be the lower bracket of the compensation levels, but every claim's different. The circumstances of every claim are different. So on the serious end, and there are plenty of those, and incidentally, that's not to diminish the impact on all the postmasters, because those that had a low financial impact of what Post Office did may nevertheless have been very severely impacted in terms of how it made them feel and the stress we were put under. Yeah. But on many of the cases, we're getting medical reports which evidence the psychological damage done to people or the illnesses that have been caused. We're getting accountants' reports from forensic accounting experts, and all of that, of course, takes time to obtain, and then it takes time for government and their lawyers to review it. That's all a process, but it is a process that we need to go through to make sure that the proper evidence is put in to government as to what these people have been through, so that we ensure that we get fair compensation payments for them.
Just finally, because we're running out of time, but Post Office Limited were very close to covering up this entire story. How proud, you're not a man who likes to blow his own trumpet, by the way, but how proud do you personally feel, and how proud are you of your extensive team and all those different parts of all those different teams that have come together to secure this win and to now be bringing this into the, properly into the light?
I'm very proud for everybody involved. Proud of Alan and Kay, who worked closely with Alan all the way through. Proud of the Henderson Chambers Council team, who worked 20 hours a day throughout the really, really heavy parts of the case, as did our team. Proud for the postmasters, who were brave enough to bring the case to the High Court. And absolutely proud of my team, because obviously I could not have done the case on my own. Wouldn't have even been able to start doing it on my own. So I mentioned Imogen Randall at the beginning, and also Chloe Oram. There were lots of other people in the Freeze team, and proud of the fact that we as a firm have had the skills and resource, and we were able to deploy those in the case is a privilege.
And a thank you to every single one of those people that spent that extra hour in the office, sometimes for no reward, just because they felt so passionate about the case.
Absolutely. And it was one of those cases where, we weren't having to ask our team whether they could work a few more hours. It was saying to them, listen, you need to work less hours because it was so intense.
James, it's been absolutely fascinating talking to you. Thank you so much for sharing it with us and sharing it with the public now via John Hollingworth in the drama.
Absolutely.
It must be odd to see your mannerisms on the screen like that.
Yeah, people keep pointing out to me that certain mannerisms I didn't even know I had that he's picked up on. So absolutely bizarre to watch that.
I think he even borrowed a pair of your glasses to film some of the cases.
Yeah, he absolutely did. Yeah, no, he's been very conscientious and thorough in playing me in the drama.
Well, congratulations to you and the whole team at Freeth. Thank you so much for your time. Unfortunately, that is all time that we have time for this afternoon. Thank you, James. It's been a privilege, as I said, to chat to you about this extraordinary case and its ongoing ramifications. A lot to digest about not only the Post Office case itself, but also the importance of identifying corporate and reputational risk. I hope our conversation today has been useful and inspiring to our audience here on LinkedIn. Thank you so much for joining us and for some of your questions that I tried to incorporate. And if you'd like any more information about how Freeth's early risk mitigation team can help you, then do please get in touch. The email address for that is risk.management@freeths.co.uk, and they'll be happy to hear what your questions are and get back in touch with you. But for now, from James and me, goodbye.